跟住落嚟香港家庭傭工。
Next, Hong Kong Employers of Domestic Helpers Association, Mr. Joseph Law. Thank you, Chairman. We have received many complaints from employers. So 6 years ago, we have asked the Labour Department and LW Bureau to step up enforcement, but we have not had any proactive response. So we hope the Labour Department will look at the complaints received by us, and we'd like to make the following proposals. First of all, there should be a special complaint receiving mechanism for FDH-related matters, and it should be widely publicized. Secondly, the existing hotline cannot discharge its proper function. Number two, all the EAs and the entrustment documents should be in uniform format. Complaints have been received from employers saying that the documentation used are in different formats. Number three, there should be a guideline for operation, including penalties. If there is serious breach on the part of EAs, there could be revocation of license. And also we should review whether in the law we have sufficient powers for enforcement and prosecution. Next, the EAs should not force employers to accept another FDH if the chosen one does not come to Hong Kong. We believe within 45 days, if the chosen FDH does not arrive in Hong Kong, then a big part of the fees should be returned to the employers. Next, the Labour Department is the licensing agency, and it should take up the responsibility for receiving complaints, doing monitoring, and also doing investigation. You should not ask employers to go to the Consumer Council, which does not have prosecution or investigative powers. Last but not least, we hope the administration can state that the Philippines consulate should not be dealing directly in the contracts. Now the Philippines consulate can do it, but the Indonesian consulate is not willing to do it, and the employers have to pay tens of thousands of dollars to tackle contractual problems. Thank you. Next, FDH Agency Problems Concern Group, Ms. Liu Ming Chu. Good afternoon, everybody. The administration licenses EAs, but you only tackle the symptoms of the problem. Employers have also told us that Hong Kong laws actually do not protect employers. Employers have to pay a fee to employ FDH. But why is it that nobody protects the employers and nobody supports us? The employer will say he hires an FDH and he is at the mercy of the system. The EA only releases part of the information, say the CV of FDH. Of course, we trust the EA's CV information, but we would ask whether this particular FDH would suit the situation in the home of the employer, and the EA would always say the FDH would know Cantonese, and if she needs to take care of children, she will be excellent in providing the care. And if you say you have an elderly person, they would say the FDH is excellent in taking care of elderly persons and escorting them to doctors or hospitals, etc. But then when the FDH arrives in Hong Kong, you will find that actually the FDH doesn't know Cantonese at all. And the EA will say something else then. They will say, actually, it is very difficult for the FDH to learn Cantonese. It is very little that they are using. But then if you also ask that the FDH has to take care of children, but if she doesn't use Cantonese, then what would happen if the children fall sick, maybe have a fever, and the FDH would have to take the children to a doctor, but then there will be no way to communicate. And then the EA will say the CV is only declared by the FDH and it has not been checked by the EA. Now, I believe the administration should stipulate that the CV should have been checked and verified by the EA. I think you have to tell the EA also to train the FDH, and the administration should stipulate the content of the training course. And actually, the EA should seek to understand and check the background of FDH before introducing them. Thank you, Ms. Liu. And then FDH and employers should be strong. Ms. Quindy Chow. I would say that for employers, we are having so many problems. The FDH's work attitude, and I think everything has been slipping. This is because the administration is not doing its monitoring role. The FDH job hopping, they always make life difficult, so they get sacked, and they would actually turn the air ticket into money, and the EAs also stand to gain. And also there could be 1 month's salary in lieu of notice if the FDH are sacked. So employers lose money. They also suffer psychological pressure. And the Immigration Department, since August last year, has not done anything to stop job hopping by FDH. The situation has not improved at all. I would ask the administration that you should protect our rights. First of all, you should stipulate that within the first year of the contract, if FDH do job hopping, they should be repatriated and they should not be given another work visa, so that the visa quota can be given to other FDH who really want to work in Hong Kong. And number 2, you should review the immigration ordinance. If FDH do not exactly leave Hong Kong for 2 weeks, if they just go to Macau to get another work visa and come back to Hong Kong to take up another job, then actually they have not gone back to the place of origin. I hope this will be reviewed so that in that case, employers should not have to pay the return ticket because it is totally wasted. I hope the administration will really tackle these problems of job hopping by FDH, plug the loopholes, protect the rights of Hong Kong people so Hong Kong families can live and work happily so that we can continue to fight for the benefit of Hong Kong. Next with Ms. Helen Wong from FDH Agency Concern Group. Thank you. I am a victim. I'm a member of this concern group, and many of my friends have also been victimized. The immigration and labor laws of Hong Kong are very unfair to us. It says if we terminate the contract, FDH should return to the place of origin by the most direct means. If they do not go back, if they just go to Macau, Guangzhou, and come back, and then they can go to another employer. But employers like us have to pay about $2,000 for the air ticket, and we also have to pay 1 month's salary in lieu of notice. We believe the law is not ideal, and therefore the FDH are job hopping and the number is increasing. The labor law also stipulates that if they break something at home, at most they will have to compensate $300. But many articles in my home have been broken. You should review the law because we have been victimized by FDH. And also, EAs have a lot of business, and therefore, some of them are persuading FDH to job hop. So if they go to a new employer, EAs will then have even more business in terms of agency fees. That is why we think that this is criminal, and yet they are not taken to task. I also heard our chairman say that if you don't go through an EA, the Indonesian consulate will not give the visa. I hope you will try to understand why Philippines is helpful, but the Indonesian government is not willing to do this. Okay, next. Ms. Leung Bronthy from FDH and Employers Rights Protection Group. Thank you. Actually, we have a serious problem now. The quality of FDH is slipping, and this is because the policy is inclined to favor them, and EAs are unscrupulous and they are cheating us for more profits. Now the law does not regulate EAs, so unscrupulous ones get introduction fees from employers. They also have air ticket money, and they are still telling FDH to job hop, and in fact sometimes they introduce FDH to us who cannot actually work in Hong Kong, but sometimes we have no choice, and they do not abide by the spirit of the contract, and that is why we have a FDH of lower quality nowadays. In order to improve the EA system, we believe the administration should introduce a demerit point system for EAs. And there should be a licensing system for EA operators, so they know what the law requires of them, and so that they will not provide partial information to mislead employers. It is just like estate agents and insurance brokers. They have to attend examinations in order to get a license. Very early on, Singapore has got this system for employment agencies so that they are on a par with other professional people, and society will find EAs more acceptable. I would actively ask the administration to learn from the Singaporean example, that you should have a demerit point system for EAs, and also in the long term you should have a licensing system for EA employees themselves, so they have more professional knowledge, and in the end we can protect employers as well as employees. Thank you. Ms. Lian Chan from FDH Policy Concern Group. Thank you, Chairman. According to the standard employment contract, when FDHs come to Hong Kong, when they go for body examination, etc., all the fees are paid by employers, and then we have to pay salary, for medical attention and meals, etc. According to the Liberal Party survey, you need to expend $7,000 to $8,000 every month on an FDH. This is by no means a small amount for the average middle-class family. Right now, when FDH apply to work in Hong Kong, they have to go through EAs, and employers do not know these FDH beforehand, but EAs are of different standards, and they sometimes do not have professional knowledge, so employers know nothing about the FDH before they come. The administration therefore must come up with concrete measures to protect the rights of employers. We believe you should consider setting up a 3-month probation period. In those 3 months, the agency can only get part of the agency fees from employers, and after the probation period, the employers will have to pay up the entire agency fee, so that we will know the FDH before they come to Hong Kong.
And also, I hope that the immigration ordinance can be reviewed so that prospective employers can request the employees to provide the past record of their performance and their work record in Hong Kong to offer better protection to employers. 跟住副主席係Filipino migrant